this webinar. The facts and circumstances that might apply to you are very specific, as you'll see throughout this webinar. The city you live in, the kind of property you own. And so this is meant to be a broad overview that gives some specific topics to look out for and essentially an issue spotting. We can help you later on with your specific questions. However, this presentation is intended just to be a broad overview and to get you thinking about the kinds of things that might come up as a renter, or as more importantly as a landlord for these shared spaces and sharing economy. My name is Simon Offord. I'm an attorney here with the law offices of Peter and Brewer. We are a real estate specific firm. Our practice is all about all kinds of real estate matters, ranging from landlord tenants, obviously as we're doing this, to commercial leasing, homeowners association issues, and virtually anything that encompasses real estate law. We do both litigation and transactional work. The sharing economy is booming right now, and in the Silicon Valley, it's probably booming more so than anywhere else. The sharing economy isn't just limited to the idea of renting out property. We're seeing things like Uber, rideshare type sharing services. There's carpooling services now. I recently sold a couch on Craigslist, and the person that bought the couch didn't have a way to transport it to their home. This is in San Francisco, so they don't have a truck or anything like that. There's a new service called Lug, where a couple movers came over, and for actually a fairly generous fee, I think it was only $50, they moved the couch to her house. So these sharing economy, sharing services are becoming bigger and bigger. TaskRabbit is another one, which is really interesting, where someone will basically do anything you need them to do, whether it's drive you to the airport, go wait in line for you to buy tickets or get reservations at a restaurant, to cleaning your house or painting your house. So the sharing economy is huge right now. Our focus today is obviously going to be on real estate. The trends and the reason why this is so popular is the real estate market in the Bay Area, as we all know, is crazy. There's a lot of money to be made if you own real estate, and there's also a need for it to offset some of those high mortgages that people are paying. And that's why sites like Airbnb and HomeAway and FlightCar are thriving right now. There's just a need for this sharing economy in order to supplement your income or help pay your mortgage. However, as things become more popular, as we know, the laws get more complex, more regulations come in, and then what is always the case is when you have new laws, there are somewhat blurred lines and issues that go unresolved. Just because a law is written doesn't mean it's well written. And oftentimes questions arise as to what a law means and how to interpret it. And some of these issues, frankly, haven't been interpreted yet, because that's the job of the courts. And if a law is made, it oftentimes takes several years to get a case to litigate that issue and give you a resolution. So some of the answers I'm going to give you, unfortunately, are not very clear, because there isn't much law on this yet. It's a brand new topic, but there are some very basic guidelines that we can help you with. The first question, obviously, in the shared economy and this idea of listing your property is, can you even list it? The first thing that as a homeowner you need to look to is the municipal codes. Each city has their own rules or doesn't have any rules. It depends on the city. The big news recently was the proposition in San Francisco that was put to ballot for vote that was not successful. San Francisco already has specific rules regarding short-term rentals. However, this new proposition this year sought to further clarify those and frankly further limit the ability to rent out your property short time. So San Francisco is a good example that we'll look at a little more closely later on in this presentation, so you all can get a sense of what kind of stuff is possible in these regulations and what other cities might be doing soon. A lot of cities don't have any regulations, so you might be in luck there, but that doesn't mean you have carte blanche to go ahead and be involved in this shared economy or short-term renters. Counties might also have regulations. So if you're in an unincorporated part of your city, you then need to look into the county regulations. And if you're in any city, you always need to look to the county regulations to see what they might say. Now, these municipal code sections also apply to the renters, not just the owners. What some people might not realize is that tenants can sublease out essentially on short-term rental sites parts of the property or the whole property. So the tenants also need to know what the municipal codes say about the rules. The next place people need to look for both property owners and again for tenants are the homeowners association CC&Rs. This is a big one. CC&Rs can be changed and amended by vote of the association, and we've had a lot of both pro short-term renters and anti short-term rental people come to our office where either they want to change the CC&Rs or they're trying to prevent the CC&Rs from being changed, because now that this is becoming such a big issue, those homeowners associations that don't have regulations in place already are looking to put them in. And so the first place you need to look if you're in a homeowners association, a townhome, a condo, etc., is what your CC&Rs say. Are you even allowed under the rules that govern your association to have short-term rentals or guests? Becoming more and more common that the short-term rentals are restricted, so you need to be very sure what you are allowed and not allowed to do. CC&Rs are the place you're going to find that. And then finally, if you're a tenant seeking to sublet out via short-term rental your space, the place you obviously need to look, in addition to the CC&Rs and the municipal codes, is going to be your lease. The lease terms, most leases typically have information and some sort of provisions or restrictions on subletting, assigning the leases, or guest clauses. Specifically, renters are going to want to look at those guest clauses and subleasing issues and how those are addressed in their lease. Most standard leases contain some sort of restriction that requires landlord approval. So as a tenant, if that's the case, you risk being evicted if you don't follow what the lease allows you to do or not to do. And so getting approval is always probably the best interest. Now, some landlords might take issue with this. What do we do about that? Well, if your lease says you can't do it, you can't do it, but you can always try to negotiate with your landlord. These are negotiable contracts that you have. A lease is not something that can never be changed. So if you need to try to revise your lease or work with your landlord, you can offer some sort of a bonus for the landlord, say giving him or her a percentage of the income that you make, or offering to pay a little bit more for rent. So just because your lease says you can't do it doesn't mean you can't get around that, but you certainly have to look to the lease before you make any decisions here. So those are the places that you look for restrictions. Now, what kind of restrictions are we talking about? They're quite broad, to be honest, and again, it depends on where you're looking. But one typical restriction we're seeing in San Francisco, again, is a good example of this, is the number of rental days. Is there a cap on the number of times or number of days in a year? That's common in a lot of cities that are instituting rules, and surely more will be coming down path. Are there limitations on consecutive days? This is an important issue because consecutive days can create a tendency, and we'll get into this a little later, but you always want to be wary of leasing for any time exceeding 30 days, because then you come into a situation where that person that's rented your space on a short-term basis might all of a sudden have rights as a tenant, and that's a really scary topic that we're going to get into in a few minutes. The next issue is record keeping. There's going to be specific restrictions in place in a lot of cities about record keeping. And the cities have made clear that this is not something that you as the property owner can put off to the service provider, such as VRBO or Airbnb. You yourself have to be responsible for keeping records. And what kind of stuff are we talking about here? Rentals, how many rental days there are, what price you were renting for, how many consecutive days. This is the kind of information that you're going to need to track, not only to comply with city guidelines, but also potentially for your own tax benefits and all that. So that's something to keep an eye on is the record keeping. And you want to keep clear records that have receipts and proofs, so that if the city ever comes after you, you have a quick resource in order to defend yourself and hopefully not have to call us. The next issue is permits and registration. Cities are instituting requirements that you either have some sort of business license and or you register with the city, get a permit, apply, and make sure that the city is aware that you're doing it. And if you don't follow these restrictions, there are specific penalties in a lot of cities. So you want to make sure that you comply with all these requirements before you begin leasing. The next issue is a big one is taxes. For instance, a couple different cities have what they call transient occupancy taxes, which are essentially hotel taxes. Those can range from anywhere to 7% in some cities in Southern California. San Francisco right now is at 14%. So that's a pretty large percentage of your income. So that's something you need to think about and also track. Again, the owner is responsible for this information. So you cannot say, oh, well, I thought Airbnb was doing that for me, or I thought Lyft was monitoring that for me. No, that's typically going to be the owner's responsibility. We don't want to be relying on these third-party sources, and you can't rely on them under a lot of the laws. So that's the next kind of restriction. And then there's this idea of limits on revenue, and this is an issue that's specific to tenants. Renters in San Francisco, for instance, are not allowed to exceed their monthly rental amount. And the reason for that is San Francisco has rent control. So if you're in a unit that you've been in for 30 years and you're only paying $750 a month for it, you can't then all of a sudden make a massive profit by renting out your unit or a portion thereof for the entire year or 200 days, and then all of a sudden you're making a lot more money than you're paying in rent. That's the situation we want to avoid. That's taking advantage of the rent control, and that's something that's going to be restricted in San Francisco and likely a lot of other cities. Again, as this law develops and as cities start passing ballots over time. So those are the general kinds of restrictions that we need to look out for. We wanted to give you some more specific examples so you can understand, okay, well, what kind of restrictions are these? How punitive can they be? And what do they include? San Francisco, big city, always on the forefront of tenant rights, for better or for worse. And so we're going to look at San Francisco, what they have done. San Francisco recently had the ballot measure that, as I mentioned earlier, did not pass, which sought to further restrict what the rules we have are here. And I'll mention some of those kinds of things they were looking to do in San Francisco as we go through these. So the first issue is, and this is probably the most important one in San Francisco, is that you have to be a permanent resident, and there's a limit of 1 unit per person. You can't be a permanent resident of multiple dwellings, and so this is basically restricting making this a business opportunity. You can't own several units and rent them all on Airbnb under the current structure of the law. You have to reside in the property 275 days or more a year. And this is part of your registration process and vetting. San Francisco has actually established an office specifically for these short-term rentals. So they're taking this very, very seriously. And the fines are quite punitive, frankly. So that's the first rule in San Francisco. Next rule, there's a 90-day annual cap for the entire unit. So what does that mean? If you're renting out the whole unit, say your whole 2-bedroom condo, the most you can rent it out for is 90 days. That means that you have to live there the other 275 plus days of the year. That's what the first rule says. So that rule was sought to be limited down to 75 days in the ballot measure, which obviously did not pass. Now, the caveat to this is if you're on the premises, if you're present at the property, there is no cap. So if you have a 3-bedroom house and you're only renting out a room, then there's no cap for you there. So those people that have 3, 4-bedroom homes, possibly have some sort of legal granny unit or secondary unit, those people can avoid this cap issue because they're actually present in the unit. So here on the slide it says doesn't apply if posted. That's what that means. That was something that the ballot measure also tried to take out, was they didn't want any differentiation between a portion or the entire unit and whether you were occupying it or not. Again, that didn't pass. So as the law currently stands, 1 room out of your 3-bedroom house is okay for the entire year, essentially. You'll see here, I mentioned the fines are fairly punitive. It's $1,000 per day is what they're doing right now. So there was a case in New York where the fine was similar in the $1,000 to $1,500 range. I can't remember exactly what it was, but someone had leased out their unit for 30 days more than they were allowed, and so they were looking at a $30,000 bill from the city. So this is serious stuff, and big cities like New York, San Francisco are really taking it seriously. The next restriction that San Francisco has is this registration process. There's an application, there's a fee, a fairly nominal fee, but there's a fee to apply. This application has to prove that you've complied with all their requirements. What are those requirements? You have to have some sort of insurance, liability insurance for at least $500,000 that specifically covers short-term rentals. There is an exception that if the service provider such as VRBO or Airbnb has insurance, then you might be able to get around that. But for as an attorney, I'm always worried about liability. You're going to want to have your own insurance here, and the city requires it anyway. The property can't have any code violations, which is really interesting. So you got to make sure you're up to code, and you also can't be renting out illegal spaces. So San Francisco, if you rent out your garage that's been illegally converted, the tenant still has rights under rent control. But for these short-term rentals, they're saying, no, you can't rent it if it's an illegal or unpermitted space. So that's something that a lot of people, that if you're thinking about transitioning from having a full-time tenant in your illegal granny unit or in your illegal garage that's been converted, you're not going to be able to use these short-term rental services. So that's going to be a big deterrent for people. As I mentioned at the beginning, the primary residence is one of the requirements, 275 days a year. And San Francisco is also requiring you get a business certificate. So none of these are overbearing things you have to do, but they are things that you need to keep track of. And obviously need to be part of the application process. The next restriction San Francisco has, and this is one that should be followed no matter where you are, is this 30 days or less rental period. In California, if an occupant has an agreement for more than 30 days, then they all of a sudden have rights as a tenant. If you have rights of a tenant, it's a lot more difficult to get someone out of the property. You begin facing issues with potential rent control claims from the tenants. Getting them out is going to be a much more difficult process. So this is something that's critical to watch out for. San Francisco has a specific rule about it, but no matter where you're doing this, you don't want to be renting out the space for more than 30 days at a time. Airbnb lets you do that, I believe, under their platform, but that's something that you don't want to touch here in California. The next one is there's essentially a hotel tax. They call it the Transient Occupancy Tax in San Francisco, and that's 14% of the revenue. So that's a pretty significant issue. Again, you have to track that yourself as the host. And so whether you want to build that into your rate or how you determine that is up to you, but you got to keep in mind that you will have that tax responsibility to the city. Next are going to be your advertisements. As I mentioned, you have to register with the city. When you register with the city, they're going to give you a registration number. That number needs to be included in all the places where you register your property and advertise it for lease. So, for instance, in your Airbnb listing, you need to say 123 Main Street, San Francisco registration number ABCH. That's what you have to do. That's what the rules say. Let's not risk breaking the rules here. Simple thing to do. Next, as I also mentioned, there's these record keeping requirements. San Francisco has specific ones where you need to track the number of days rented, keep in mind the consecutive and total days issue. And then finally, there's a safety concerns component that San Francisco has instituted. So just like when you stay at a hotel, on the back of the door there's a set of instructions about where the exits are, where the fire extinguishers are. That's required in San Francisco. So you have to have these safety concerns addressed. Where are the exit signs? Where are the fire extinguishers? Where are the gas and water shutoffs? That all needs to be placed on the back of your door. Again, not something difficult to do, but surely something a lot of people don't know and can get you in trouble if you don't have that. So that's San Francisco. San Francisco tried to tighten that up even further with this ballot measure that did not pass, but I wouldn't be surprised if it happens again. And we're certainly going to see this happening in other cities. cities have money to be made here, and as we know, our government always likes some more money. So don't be surprised when this starts coming down in your city if it hasn't already. Um, and then also, there's going to be a lot of pressure from tenant advocacy groups about making sure that cities still have affordable housing for the local employees and workers. And so that's the big reason why San Francisco has been pushed in to try and make all restrictions, and it's going to happen throughout the peninsula. We all know the housing crisis that is here. There's only so many houses, and they're not cheap, and so cities are cognizant of that. Okay, again, as we mentioned, how to find the restrictions, looking on the muni codes online, looking at your CC&Rs, and looking at the lease that you have. Okay, now for the fun part, the potential issues. Let's assume we get through all those hurdles. We've registered, either our city requires it or doesn't. We're ready to go. We're excited. We're going to make some money. Well, here I am, the big bad lawyer, going to tell you about the potential issues you face. These issues are significant, and I think Airbnb and VRBO and these sites are great services that provide a real benefit to homeowners. But these are the things you need to consider. These are the risks you're going to potentially face in a short-term rental situation. The first is the potential for nuisance claims. Whether it's in your CC&Rs or not, there's always a risk that you might upset your neighbors. And your neighbors are entitled to the right to use and enjoy their property freely, and it's called the quiet use and enjoyment of their property. Having these short-term tenants can be an issue in that they can create a nuisance. We can have house rules. We can try to screen our tenants. We can do everything we can, but the bottom line is you can't control renter behavior. If everyone followed the laws, I probably wouldn't have a job. So you got to expect there's going to be some tenants that might be disrespectful, that might not follow the rules, and that can create potential problems. Further, as I mentioned, this might be a violation of your CC&Rs. A lot of homeowners associations have very specific rules about what can and can't be done. When can the hot tub be used? When can the spa be used? All that kind of stuff. So that's something we need to look at, and the risk that your occupants might violate those rules. What are the kinds of things we're talking about? As the slide says, noise. If you have a 3-bedroom house and it's being constantly rented to 6 or 7 occupants or more, which we've seen, what kind of noise issues is that going to cause for your neighbors? Are they going to be having parties in the backyard? A big hot issue now is people looking to rent out their spaces for the Super Bowl. Okay, the Super Bowl is a big party, right? So if you're renting out your space, you have 2 people applying saying, yeah, it's just going to be us, but then they bring all their friends over after the game and they've had a few beers. Is that going to be an issue, and is that going to upset your neighbors? This is specifically an issue when you get someone that's renting year round and there's constantly more people staying in the house and they're making a lot of noise and they're having parties. We've heard of situations we've had clients complain that their neighbors were using their property as essentially a think tank for a tech company. And so there was 15 people staying in a 4-bedroom house with bunk beds everywhere. You're going to have some added noise there and people in the backyard late at night and partying and hanging out or even just talking. If you've got some overpopulated house with several people in the backyard over the course of a year, that can get pretty burdensome, and you might upset your neighbors there and be looking at a potential nuisance claim from that. Other issues are things like smoking. You have tenants you can have house rules that say you can't smoke. That doesn't mean they're not going to comply. That not only is an impact on your property and it's offensive smell that now is going to linger if they do it in the property, but if they're going out on the balcony in a condo association and smoking, is that allowed by the CC&Rs or not? Or is that going to upset your upstairs neighbor? Same thing with a house, an issue to think about. Parking and traffic, again, let's look at that situation where there was 15 bunk beds in a house. All of a sudden now you've got 10 cars parked in the street. Is that allowed by the CC&Rs, or is that just a general nuisance? Extra traffic, people coming home late at night, all that, something else to think about. Finally, pets. Do your house rules have a specific rule about whether dogs or cats are allowed? Are people going to follow the rules again? So another thing to think about there. And again, a lot of CC&Rs restrict pets, so is that going to be an issue? Access is another big thing. I personally live in a small building with 6 units. Do I want the neighbor across the hall from me having a new person come in every day? Is that going to affect my feelings of safety and security in property? So you have this high turnover. You're giving out keys to people. Are they going to make copies of keys? You know, HOAs and townhomes and common interest developments will have common areas. Are those going to be impacted? Are your bikes, or do you have other storage in the common areas that all of a sudden now is at risk from being stolen? So that's a big issue of concern, and that's why HOAs in specific are really kind of nailing down on these issues, because homeowners have those complaints, and frankly, I think they're valid complaints. So how do you deal with that? Yeah, as we have here, the high turnover is the issue, common areas, and your keys and access, all concerns. I did actually see recently a pretty interesting thing that I was considering for my own house, that you can get a device now that you can put on your door, and it's a device that's run by an iPhone or an Android app, and you can give people access for a certain amount of time. So, for instance, we have a dog walk that comes every day, or if you have a cleaner that comes every week or bi-weekly, you can give them a window of access through this app where they can only get into the property during certain specified times. So, for instance, Monday mornings between 10 and noon, the housekeeper can get to your property and get in using this app. Maybe that's a way around it. You don't have a key going out that can be duplicated. It's all through a secure app. Something to consider, and maybe something we'll see more of. I think it's a pretty neat topic. All right, so again, the Airbnb contract also might have some protections, but the issue here is, are people going to comply? Again, like I said earlier, I wouldn't have a job if everyone followed the rules, read their contracts, agreed with the contract terms, and actually performed as they're supposed to. So we have protections built into both your potential house rules that you can create, or the actual Airbnb contract, or VRBO and FlightCar and HomeAway also have these. But are people going to comply is the question. And when they don't comply, that's when we have issues. The short-term occupants are going to on the day after they create a nuisance. You have to stay there, and you have to own the property. You have these neighbors that you have to worry about, in a city possibly going after you, or the homeowners association seeking to assess you. So at the end of the day, you're the one that has those here. The next issue that we have is insurance. As I mentioned earlier, a lot of these shared economy sites do have insurance protections in them, but are those going to be good enough? Maybe, maybe not. They're filled with exemptions and reasons why they won't have to cover you. Insurance companies don't want to cover you, and so they're going to find any way to get out of covering you. So if you have a following B or the VRBO contract word for word, they might say, well, sorry, you haven't complied, so our insurance doesn't cover you if you're on your own. So what does that mean? Does your policy cover short rentals? Every policy is obviously different. I've read a few different policies, and there's different kinds of things that are covered. At the end of the day, you want to contact your insurance broker if this is something you're doing to try to get clarity on this. But the type of things we see is a lot of policies will allow for a special occasion or a one-time event where you're doing some sort of short-term rental. So if, for instance, you live in Santa Clara, the Super Bowl's coming, you're thinking, this is a chance for me to take my family on a vacation and make $5,000 in a week pretty easily, then your insurance might that. However, it might require that you give some sort of notice beforehand. So again, you need to look to your policy to see what that says. Most policies are really clear for homeowners policies that say business activities aren't covered or aren't permitted at the property. So it is having an ongoing short-term rental going to be considered a business activity? Possibly. That's somewhere where the insurance company could try to push back and say, we're not going to cover you in this instance. So the way to get around this again is to call your broker, find out what your policy allows or doesn't allow, and then get some sort of rider to your policy or some sort of investment property policy instead of just a standard homeowners association policy. This slide reiterates that. What kind of policy do you have? If this is going to be something that you're renting out nearly year round, you're going to want to have that investment policy rather than the homeowners policy. I had a that was renting their policy where they initially rented, or excuse me, they initially lived in the home, and then they bought a new home, and so they moved to the new home, but they kept the old home. Well, for whatever reason, they forgot or didn't change the policy from the first home into a rental property type policy, kept it as a homeowner's policy, moved into the new home, got a new homeowner's policy for that second home, and then lo and behold, the tenant sues them. Well, the insurance company then said, well, you didn't have the right policy, so we're not going to provide coverage. So this is something insurance companies will do if they wanted to push back and avoid big settlements. So make sure that this is something that you cover. You don't want to rely on the host in the event that they say that you're not covered for some sort of violation. All right, the other thing is these holdover occupants. Sure, someone signs up for a 2-night rental, but what happens when they say, we're not leaving? Have more faith in people than I do, but if you don't have some concern that this is the case, just Google Airbnb holdover in any city in California, and there might well be a news article about it. There's been San Francisco, this has happened, Santa Cruz, San Jose. It's common. With the housing crisis we have, with the rental rates, people get into a place and they like it, they might not leave. And then what are you going to do? As I mentioned earlier, the biggest issue here is avoiding giving occupant status of a tenant. A rental for more than 30 days means that they are a tenant, and all of a sudden they have tenant rights. It's much harder to get someone out once they have tenant rights. The eviction process is long, it's costly, and it's frankly just a pain. So the question becomes enforcement versus the contract. Sure, your Airbnb contract with them will say they only have a right to 2 nights, or sure, you have some agreement and security deposit with them. But again, that doesn't mean they're going to follow the rules. If someone's in there, you can't just go in there with a baseball bat and threaten them and make them leave. Those days are long gone. The courts do not look kindly upon self-help. So this is an issue that we really need to be cognizant of, is that you can't rely that the contract is going to be a guarantee that they're going to leave. This is a possible risk. There is an attorney fee provision in the Airbnb agreement, for example. You can have a separate agreement that deals with this to try to give you some more leverage in getting the people out. But again, at the end of the day, people might break the rules, and how are you going to deal with that? And that's just the risk that you run with these short-term rentals. The next issue that, frankly, we don't have time to get into today. We've got an hour, and we're running up to the question time. Is the ADA, FHA, and discrimination claims. ADA, FHA, and discrimination are very specific. ADA has different rules to FHA. What is ADA? Americans with Disability Act. So do you have accessibility? Do you have ramps or ways for people to get in? FHA is the Fair Housing Act. Are you practicing any sort of discriminatory practices, or are there things in your advertisement that are discriminatory? These typically only apply to people that are renting out multiple units. However, that doesn't mean that you should just ignore them. You want to look specifically into the ADA and FHA requirements and see if you're covered. And even if you aren't covered, discrimination is always illegal. So the fact that you're not governed by FHA because this is just one bedroom in your house you're renting doesn't mean that someone under a state or other federal law could come after you for discrimination. So I know all of our attendees here are intelligent and great homeowners, and you're here at this seminar, so you're trying to think of these things and avoiding liability. So none of you would do any of this stuff, but it's just something that we have to warn that there's this whole other topic of law and a whole other area that we need to think about. And if this is something that you're making a business out of and you own several properties, then you're really going to be heavily regulated. So you need to make sure that you're keeping track of the ADA requirements and FHA requirements, and whether you need to perform retrofits to fit in with the standards of the ADA. The next issue that kind of goes into this discrimination is service animals. Service animals has been a hot topic that we've seen in this office recently. Potential tenants are asking if they're allowed to have their service animal at the property, and if there's any hint or indication that the landlord's not going to allow it, they get slapped with a lawsuit. Service animal issues also apply in these short-term rentals. Again, whether you apply or whether it applies to you or not will depend on your specific situation, but this is an area I wouldn't want to touch. A few years ago, we saw a lot of the ADA lawsuits, what we call drive-by lawsuits, where you would have lawyers driving around finding places that don't comply with ADA requirements and then getting a suit filed for that. The new one is service animals. So you want to be very wary about discriminating against people with service animals. Again, whether the specific rules apply to you or not, it's a case-by-case basis, but it's definitely something we want to think about. It really is a hot topic in the law right now, so something to be very careful about. Next, as just a case example, I wanted to point out a few things in the Airbnb contract that, in theory, provide you protection. Again, the question is in practicality, how are those going to play out? So the Airbnb contract has an arbitration provision. So that means you might be losing your right to a jury trial if there is some dispute that arises in one of these Airbnb short-term rentals. Is that something you're okay with or not? Different attorneys have different opinions on arbitration provisions, whether they're helpful or not, whether they are cost-effective or not. So it's something you need to consider. Security deposits are allowed under the Airbnb contract, so that's certainly something you're going to want to consider and use, frankly. Just like a long-term rental, you never know what someone's going to do to the property, so you want to have some protection for yourself in case there's damage. The Airbnb contract also allows for house rules, so this is something that is important to have. Quiet hours, use of common areas if you're in a homeowners association. Almost every set of CC&R has a separate section about the association rules. You want to make sure that your occupants are following those rules, because if they don't, then you're again the one that's on the hook. Now again, will they follow the rules? We don't know, but you want to at least have those in place so they have a sense of what they're supposed to be doing or not doing. And then also Airbnb does have a specific rule on overstays. Airbnb's rules say that if an occupant overstays their booking, they have to pay 2 times the nightly rate, they have to pay some service fees, and they have to pay the legal fees associated with getting them out of the property. That's a nice sword to have. If you get an overstay in there, you can look at the Airbnb contract and say, look, now you're going to owe me X number of dollars more than you thought you were going to owe. The problem with this is, again, enforcement. There's a lot of these stories where you have these people holding over or overstaying their reservation, and then how does that work? Well, sometimes the owners are just paying them off to get out because you don't want to deal with the hassle. So yeah, it's great that there's rules there, but the problem is what happens when they don't comply? Are they really gonna be bound by those rules? Are you going to be aggressive enough to go after them? This is something that is commonly occurring, and the issue that becomes another issue is that what happens if you have other reservations booked? Now you can't fill those reservations. So the overstay risk is real. There are punitive components associated with it to the occupants, but it's still a risk that exists. Another issue, a couple issues that we thought of that, again, we're running out of time here before we get to the question portion of the presentation, are violations of your deed of trust or loan documents. Typically, when someone buys a property and they take out a loan, one of the questions on the loan application is this a property for your primary residence? And so if you just purchased a property and you indicated on your loan docs that this is your primary residence, but then you turn around and you start renting it out on Airbnb every day, is that a violation of your loan documents? Possibly. A lot of the loan documents allow you to start renting out a property after a certain number of years, 5 years or so. But if you start renting out your property on a regular basis right after you close, is that going to be a violation of your loan? Now, do the banks care? Are the banks going to find out about it? I don't know. But it's just something to think about, that it's another risk that you might be running if you just closed on property and you all of a sudden aren't using it as your primary residence. The next question is, or next issue that arises is, you have service providers you're going to be working with in these situations. Most likely you might want to have a property manager. I know personally, if I was renting out my space, I wouldn't have the time to go let people in and meet with them and then go check property out after every occupant leaves to make sure they've left it in a good condition and all that. So there's a fee that's associated with that, and then also there's a whole separate set of contracts that you're going to have with the property manager, and what are the implications of those. Most property management agreements will have some sort of indemnity language in there, where they're going to say, if anything happens and if any tenant or occupant sues me, the property manager, for something, you, homeowner, are the one that actually has to indemnify and defend me. This could even be if the property manager was the one that made a mistake or did something wrong. So something you want to look for in those property management contracts. It's good to vet those contracts and try to negotiate out some of those terms, because the last thing you need is a property manager violating some discrimination rule, or not providing access in a timely manner, or doing something else that gets the tenant coming after you or the property manager, and then you're on the hook for that, no matter if it was your fault or not. So that's something you're going to want to look at closely in those property management contracts if you go that route. You're also going to have other vendors such as cleaning services. What are the restrictions there? What are the requirements there? And what's the cost component of that? So something else to think about. But is that going to be a problem or not? And is that going to be an extra cost that you're not anticipating? So that concludes our seminar today. We have time for some questions here. I have a couple of guests here present in the room, and we also have the forum online for questions. I see one question. Can single women hosts advertise that they only want to rent to women? Can you say that in the listing? It's a good question. That's something that we've seen come up on Craigslist. A lot of times, a Craigslist owner or subleaser will say on their listing, men only, women only. Generally, that's going to be okay, especially if you're only leasing out your personal residence, as opposed to leasing out 10 different properties throughout a couple cities, and you're saying I only rent to women. That would be a problem. But if this is the only property you own and you're just leasing out that property, that's generally going to be okay. I'm not seeing any other questions at this time. Do we have any questions in the room?
Tenants who sublease their unit because they're out of country half of the year to people you don't even know, without telling you, and you approach the tenant because of the liability of it. We have discovered that it's not that easy to get them to leave. And the primary tenant is now in Beijing or someplace. He's just doing it to cut his rent back. He feels like he's paying rent on a place he's not even occupying. So
Sure.
we run into it if we sold it on a personal basis. But your presentation does bring up a lot of interesting things since we do our own product.
Yeah, the issue with the tenants and the subtenants, and the question was essentially about subtenants. It's a concern. You want to have restrictions in your lease. If you're going to use the standard CAR, California Association of Realtors lease, that does have provisions in there about subleasing and assigning. So it's something that you want to address in the lease up front. There are restrictions in the law where you can't prevent someone from assigning the lease in order to force them to stay there and have to pay rent, even though there's a perfectly qualified tenant that they could replace. But that's a little different. Subleasing restrictions you can have. So one way you go about that is requiring consent from the landlord. You can restrict it altogether, or as I mentioned, you can work out something with the tenants where you take a piece of their proceeds. So if it's something that you're interested in, you can either charge them higher rent or say that you need to give me 20, 50, whatever percentage of the excess income that you make. So there are ways to deal with it. But again, the place to go for that is going to be in the actual lease. We have another question here. Service animals. Can you refuse service animals if you're allergic and hosting in your own home? Another great question. So I assume that means that you're only renting out a portion of one property you own, as opposed to you're essentially a public entity renting out multiple spaces. That's typically where the line is crossed, is when you're renting out other properties that you don't live in. The refusing service animals if you're allergic and hosting in your own home. Generally, I think that should be allowed, but frankly, it's something that, again, I would be very careful with. Just because you're allowed to do it doesn't mean you're going to have some sleazy attorney. Not that there is such a thing, but maybe there's one out there that would bring a lawsuit about it, and then you're just dealing with the hassle. So if the situation comes up where a tenant or an occupant asks you about the service animal issue, I would definitely want to vet that. The rules are always changing on that. It's a hot area of the law, and it's something that we are just seeing over and over again as these kind of drive-by lawsuits. So it's something you want to be really wary of. People just are going around asking this question, hoping to get a lawsuit out of it. So it's one that you really, really need to be careful about. Another question about this service animal issue, apparently it's hot for you guys as well. How do you know if the service animal is actually a service animal and not a pet? Great question. The law actually says that you essentially can ask for documentation or proof. This situation has come up in restaurants and other public places where if someone shows up and you ask, is this a service animal? And they say yes, that's the end of the conversation. You can't dig around and question them and investigate further. So not a great answer, I know, but that's what the law says, unfortunately. So you have to be very careful with that. And if someone says it, then that's kind of the discussion there. All right, we've got another question here. If all units in the development were sold as an REO, for those who don't know, that means a real estate owned, property owned after foreclosure, how do you establish an HOA? Do CC&R apply if created by a past owner? Okay, that's a fairly involved question, but generally CC&Rs are recorded documents that run with the land. So any CC&R will run with the property. You can amend CC&Rs if you don't like what they say. So if you have control of the homeowners association, say it's a 6-unit building, 4 of the owners want to amend, there's a process by which you can provide notice, establish a quorum, do a vote, and amend CC&R. So it's definitely something that can happen, but it requires specific rules to be followed that are entailed in the Davis-Sterling Act, which is the law that controls homeowners association. The Davis-Sterling Act will specifically dictate what requirements need to be met in order to change CC&Rs. If you own all the units, then essentially you can establish your own quorum and sure you can change them. So if that's the question, yeah, you have a way to do it. But again, you want to make sure you follow the guidelines in order to avoid any later claim that, well, you improperly changed the CC&R, so now the old ones still apply. And then finally, once the CC&Rs are amended, the law requires that you record those in the county recorder so that any new homeowner will be able to find those in their preliminary title report when they go to purchase the property. Next question. Airbnb host said no weapons in house rules, and the renter said he has the right to bring a gun. Who is right? That one is a tough one. I'm not going to try to make up an answer to that because I really don't know. That's a constitutional law type question, and I will say in my studying for the bar years ago, that was one that I did not like. I'm not a big constitutional law guy. So I don't know the answer to that. It's something I can look into, but offhand, that's not something I know the answer to. Very interesting question, though, I must say. All right, looking to see if we have any more questions here. Okay, I am not seeing any more questions at this time. Oh, here's one more that's popped up. If you are renting hosting room in your own residence on long, short terms, how do discrimination laws apply? Again, if this is just a single unit, you don't have multiple units, you don't own more than 4 units that you're renting, generally FHA and ADA aren't going to apply to you. Now, that doesn't mean that state laws or county laws or city laws don't apply. You still can't discriminate. So, the FHA is a federal law that applies nationwide, but there are still state laws that deal with discrimination. So again, it's not something that you really want to roll the dice with. You certainly don't want to have it in your advertising, um, and so it's something to be wary of. Just because you're not covered by FHA doesn't mean you're all of a sudden have carte blanche authority to discriminate. Not an area that you really want to touch either way. Okay, it looks like we might be out of questions here. So again, I want to thank everyone for joining us today. We are happy to assist you with more specific questions if you have them. This is again an area that I think this is a great opportunity for people. I am by no means anti short-term rentals. You just want to think of these issues before you get involved in this kind of thing. Look at your insurance, screen your tenants, make sure you understand what the city and homeowners association rules say. We'll have this presentation available shortly on our website later today or by tomorrow, certainly, and you can access it there and watch it again, send it to your friends or colleagues. We would definitely appreciate that. If you have any questions further, please feel free to contact us. My contact information is on this last slide here. It's simon@brewerfirm.com, 650-327-2900, extension 19. You can always call us and we can set up an appointment. And we're also looking at instituting a package deal to review all this stuff for you. And if that's something you're interested in, please contact us and we'll be preparing a questionnaire that has a range of services we can provide in this respect. Thanks again, everyone. I appreciate you attending and have a great rest of your week and holiday season. All right.